It's my pleasure to have you, Mr. Peter Chase, for an interview with regards to ISDS provisions. Peter, could you please introduce yourself and tell the audience what you do, as well as a little bit about your background in trade?
Certainly, I'd be happy to. My name is Peter Chase. I'm the Vice President for Europe for the U.S. Chamber of Commerce. And the U.S. Chamber of Commerce is a major business advocacy organization based in the United States, based in Washington, D.C. I've been working here for 5 years. A lot of that has been on transatlantic trade issues. Prior to that, I worked 30 years for the U.S. Department of State as a U.S. diplomat. And since I know we're going to talk a lot about investor-state dispute settlement and investment agreements, during that time, while I was in the U.S. government, I spent a number of years negotiating investment treaties. Then I was in the Office of the U.S. Trade Representative as the Director of Investment, and that was when we were negotiating NAFTA, when we were negotiating what they call trade-related investment measures at the WTO, and then a number of other bilateral investment treaties with a number of countries.
Beautiful. Could you please explain to citizens under what principles can companies sue governments using an ISDS mechanism?
Okay. Well, sure. Companies can sue governments all the time, anytime. They do so, and that's usually about domestic law issues. Governments also sue companies all the time, usually on violations of domestic law. When people talk about ISDS, they're talking about a specific issue in international law, not in domestic law. So what happens is you have two countries get together. They say that they want to improve their economic relations, and they enter into a treaty. And the treaty is about their trade, it's about the movement of people and things like that, but it's also about how they will treat investors from the other country. And they make 4 promises to each other. They promise not to discriminate against the investor because of the nationality, to give them the minimum standard of treatment required by international law. If they expropriate, because governments always have the power to expropriate, that they'll do so only for a public purpose and that they will pay compensation. And then the investor is allowed to move money back and forth to the investment. Those 4 promises become part of a treaty. They become part of international law. In order for those promises to be meaningful, they have to be enforceable. And the question is, you have 2 ways of enforcing it. One could be each time one of the parties to the treaty violates it, you could have the other government sue the government, or you could allow and empower the investor to try to settle the dispute. And ISDS, investor-state dispute settlement, is merely a description of the mechanism governments created to ensure that the investor could directly have his or her complaint heard by a neutral panel.
Beautiful answer. ISDS, in its current form, is seen by many, including liberals, as a little outdated. Would you like to see maybe a reformed ISDS?
Well, I've heard a lot about this particular debate in Europe.
Okay.
And I think that many people don't know that ISDS, this process of resolving investor-state dispute settlements, is something that the United Nations and that the World Bank have spent years and years and years dealing with. ISDS arbitration, international arbitration of investment disputes, has been going on for over 50 years. There is a set body of law run by the UN Commission on International Trade Law, UNCITRAL, that sets up how you do it. There is something in the World Bank called the International Center for the Settlement of Investment Disputes, which is specifically set up to be a forum for this sort of thing. It too has laws, rules on how you conduct arbitration. There's something called the Permanent Court of Arbitration in The Hague, which is both for private law, private arbitration, and for public arbitration. So it's a very well-established mechanism. Now, the procedures for dispute settlement, for arbitration as dispute settlement, have actually been updated continuously over the last 50 years. In the United States investment treaties, the most recent update was in 2012 under the Obama administration. They did a 3-year review of the U.S. Investment Treaty, including specifically the ISDS provisions. And what they did was they said they took another review that had been done in 2004, and they modified it, but basically they felt that what has been done in the U.S. Investment Treaty is very useful. And that treaty requires all the proceedings for all disputes under the treaty to be transparent. In fact, the hearings need to be held and open to the public. All communications need to be published. Third parties are allowed to file amicus briefs. So in that sense, it's very modern. And it's a very good and useful process. The ICSID, the International Center for the Settlement of Investment Disputes, and the UNCITRAL, the UN Commission I was talking about, both also updated their rules, I think in 2013, to simply require similar things. So, reforming, quote unquote, sure, of course that makes sense. It always makes sense to think through how you can do something better. But the principle of arbitration as a way of settling disputes is well established. That, per se, doesn't need to be reformed.
Very insightful, very insightful. The last question that we have is, a common criticism against ISDS is that entry-level costs for suing a government using ISDS are so high that small, medium-sized enterprises cannot use this mechanism, which it leaves it as a tool only for big businesses. Now, is this the case? And if so, what can we do to ensure easier access to ISDS for small and medium-sized enterprises?
You know, I think you need to go back to my first description of ISDS. It's a mechanism for enforcing commitments in a treaty under international law. So a foreign investor can't just sue a government under using ISDS. The only way you can invoke investor-state dispute settlement is if you're a foreign investor in a different country, and your host country, your home country, has a treaty, and there's been a violation of the treaty. Okay, so those are all of the conditions before you can even talk about it. And then again, it has to be a violation of those 4 promises I mentioned: not to discriminate based on nationality, minimum standard of treatment, expropriation, compensation, and transfers. So the first thing you're talking about is you're talking about a company or investor who has made an investment in a different country. So you're not really talking about small businesses, because small businesses generally don't make physical investments in another country. You're talking about, at the very least, a medium-sized business. If they've invested $2 million, that's a sizable investment for me. If you've invested $2 million in investment, okay, anything you do to try to enforce your treaty rights, or enforce the rights that are given to you on the treaty, it's going to be, anytime you go to court for anything, it's going to be expensive, right? I think that every businessman, in fact every person in any case, thinks through the economics of a decision to take a legal case. And if they think that the value of the investment, or of what's happened to the investment because of the government action, because the government has broken its promises under the treaty, if they think the cost of arbitration is going to be greater than the value of the investment that's been hurt, they won't do it. So I don't think, in that sense, making it easier for SMEs, I would prefer that ISDS never be used. I would prefer that governments adhere to their commitments not to discriminate and not to expropriate and to allow transfers of funds. If that happens, then there will never be an ISDS case at all. And in fact, over 90%, there are 3,000 treaties like this in the world. Over 90% of them have never heard an ISDS case. There's a perception in the debate here in Europe that somehow that there are going to be thousands and thousands and thousands of cases, which, to me, based on the evidence, makes no sense. The United States has investment treaties, concluded investment treaties with all of the Central European countries that had been in the Warsaw Pact in the mid-1990s. They all have ISDS. Those countries adopted the entirety of the acquis communautaire, 80,000 pages of legislation, not a single ISDS case because of the adoption of that legislation. Our governments, good democratic governments, they enter into these treaties because they don't see that they will violate them. And if you're not going to violate them, then you're not going to, you don't have a problem. The United States itself has been sued, I think, something on the order of 30 times. It's never lost a case. You know, companies think, in this case many of the investors were Canadian, that brought these cases. They think that something that the U.S. government has done has violated the treaty commitment. That's a serious thing to say. And it was important that the U.S. government be able to defend itself well. Because if you think about it, what if the U.S. government had been found to have violated its treaty commitments? That's pretty serious too. For those of us who believe in a rule of law, we want governments to do the things that our constitutions require, to do the things that our treaties, that the treaties we've entered into require. And anyone who believes that the rule of law is an important part of democracy, is an important part of the societies we want to live in, then needs to think through, as U.S. and other government lawyers have done, what's the best way to make sure that that rule of law is enforced. And that's what ISDS is all about, enforcing the rule of law. It's well-founded in the UN, in the World Bank, in many, many international institutions, and the discussion about it here seems to have missed completely the point, that we want our governments exist to serve us, as individuals, as companies, as businesses. They have to do so within a rule of law that ensures that they don't overstep their bounds, as we know governments can do. So I think, again, that this is a specific thing about investors going from one country to another. It's about creating a rule of law that protects that and creating a mechanism to ensure that rule of law is enforced. I think it's a great thing.
Beautiful. Mr. Chase, we just want to, on behalf of the European Liberal Forum, we just want to greatly thank you very much for giving us the opportunity to ask these questions, as I'm sure many Europeans and people around the world would have the same questions. Thank you very much.
Well, thank you.